It is wonderful to be here. I will start with a few observations to build on the challenges that Toby set out. The first challenge is that Toby is actually my boss as part of the SIC Court of Arbitration. The second challenge is that in arbitration, we are typically sitting rather than standing. Toby, of course, acts in both litigation and arbitration, and I still have that same challenge of post-lunch. I wanted to tell the story of Singapore and the story of the Singapore International Arbitration Center, but I don't want to tell it in a way where we're talking about our success. I want to tell it in a way as one friend would to another, and how this potentially can be replicated in Pakistan. So if you look at the London principles, of course, these are principles that are fundamental to establishing a jurisdiction as a destination for arbitration. But there are also a lot of soft factors, some of which Pakistan and Singapore share, that can go in to make this a place for arbitration. So how did Singapore do it? And I think this is why the story is compelling. If you look at jurisdictions like London, they have been doing arbitration for hundreds of years. But Singapore managed to do it very quickly, really within 30 years. And according to the Queen Mary University of London White and Case survey, Singapore is now tied with London as the most preferred legal seat of arbitration in the world. SIC, for its part, is now ranked as the second most preferred institution in the world in that same short space of 30 years. So, of course, you need to have the legislation. Singapore has incorporated the UNCITRAL model law with some amendments, but you also have to be proactive with your legislation. Singapore is continuously updating its legislation. We see updates and amendments such as providing for the enforceability of emergency arbitrator orders and awards, abolishing the torts of champerty and maintenance, expanding the arbitrability of IP disputes. All of these have been very important in making sure that Singapore is at the front of the curve. And what Singapore also does very well is that it listens to all of the stakeholders. So every time the Ministry of Law is updating the arbitration legislation, every stakeholder within the Singapore ecosystem will be able to share their views. That second principle that Toby discussed in terms of the London principles, which he worked on the drafting thereof, is having a pro-arbitration judiciary. So I look at some of the language from Singapore judgments that gives an idea of the tenor of Singapore jurisprudence on arbitration. Language such as that the rule of law will be applied without fear or favor, and that there is an unequivocal judicial philosophy of the facilitation and support of arbitration. And I'm heartened, as I was reading on the way over, of that similar language from Pakistani jurisprudence, from Justice Hassan's recent decision. If I could quote, "Trust will be shaken irretrievably if the courts of Pakistan were to evince an anti-enforcement policy by seeking shelter in the nebulous concept of public policy." And we have also, of course, heard public policy described as that unruly horse. And similar to Justice Hassan and other members of the judiciary here, is that many of Singapore's judges are former arbitration practitioners. So there's a really keen understanding of the arbitral process. Singapore is also advantaged by geographic and cultural connections. Look at where Singapore sits in the world. It is at a hub of commerce. There are easy connections into Singapore, and that is not dissimilar to Pakistan. So when I look at SIC's caseload in Singapore, when I'm standing on the rooftop of my house, I can see Indonesia. Indonesia will be a top 5 global GDP in 2030. The cultural connections with India, China, all of the ASEAN countries, that is where Singapore sits. And Singapore has become trusted as a place to resolve any kind of dispute. And that's what we're talking about today, because it's not just arbitration in Singapore. It is arbitration, mediation, litigation. And I think increasingly in dispute resolution processes, we see some of these mechanisms being combined. So you might have a period of mediation and then arbitration with the strength of the Singapore Convention on Mediation, or SIC as a process where arbitration first, then mediation, then arbitration. So if you look at Pakistan's trade with China, potential relationships in MENA where there are those big growing economies. It is at a very convenient place in the world for arbitration. So you do have those geographic and cultural connections where it really can work here. Singapore is similar to Pakistan as well in that we are both common law jurisdictions surrounded by a lot of civil law jurisdictions. And one thing that we do in Singapore, with everything we do, whether it's rule-making, legislation, we are always making sure that we're giving effect to both the common law tradition and the civil law tradition. So that's the Singapore Dispute Resolution Framework. Let me talk quickly about SIC, which is equally compelling because it happened so quickly. In 1991, as the story goes, SIC, in its first year of operation, received 2 cases. Now, how do you get 2 cases if you've just started an institution? I am told, and this is part of the SIC lore, is that both of these were ad hoc cases that the parties then agreed to convert to this new institution, and this was part of the local buy-in. Then in the barnstorming 30 years that followed, SIC moved from a regional institution to this truly global player. Now, of course, you have to have innovative, updated rules, but one thing that SIC did very well is by internationalizing the institution. And this was the brainchild of the Minister of Home Affairs and Minister of Law in 2009 to really make SIC international. And so I'm the registrar of the SIC Court of Arbitration. Toby is the vice president. Within the secretariat, we have 16 international arbitration lawyers. There is 1 Singaporean. It is international lawyers qualified in 13 jurisdictions to match those 109 jurisdictions where parties have entrusted SIC with their cases over the past 5 years. I heard a joke made in a slightly different context, and I would like to try to adapt and evolve this joke here. Someone was talking about a list of proposed arbitrators, and he said, this list looks like it's out of the 1990s. And so what I would propose to do today is to call on all of you to look at your existing dispute resolution clauses and to consider your dispute resolution clauses to make sure that they're not out of the 1990s. Because that is one of the fundamental principles of arbitration that makes arbitration in Pakistan so compelling. There are a variety of different ways that you can construct your dispute. So you could have a Lahore seat, SIC administration, Pakistani law applying to the substance, Singapore law applying to the substance, a different law applying to the arbitration agreement. And then I thought that I should close with a hypothetical arbitration where I can look down this panel and see how this arbitration could be populated. So why don't we say that the parties have agreed to use the SIC rules. Lahore is the seat of arbitration. Pakistani law on the substance of the dispute. The venue where there's a hearing, if it's not a virtual hearing, is one of the new ADR centers in Lahore. So the hearing will be in Lahore. Waleed is counsel on one side of the dispute in this hypothetical arbitration, and any of you as barristers and solicitors, because anyone can represent a party in an SIC arbitration, you are opposing counsel. Nudra is the sole arbitrator. Toby, as vice president of the SIC court, will be deciding the most important procedural questions in the arbitration. Justice Hassan, as it is a Lahore seat, will be deciding any applications to set aside. And to me, that is arbitration in 2023, and that is the direction of arbitration in Pakistan.